So, in this session on IUU fishing, I'm very pleased to welcome our four presenters today. Our first presenter is Dr. Camille Goodman. Camille is a senior lecturer at the Australian National Centre for Oceans Resources and Security at the University of Wollongong. She is also a visiting fellow at the ANU College of Law, and in a former life, she was an advisor to the Australian government. Camille, can I invite you to present now?
Thanks very much, Joanna, and good afternoon, everyone, or perhaps good morning, depending on where you're joining us from. It's a real pleasure for me to participate in this seminar and to provide some thoughts on the complex challenge of IUU fishing. Over the last 20 years, IUU fishing has proved to be something of a wicked problem for international law, which requires a large and constantly evolving toolbox of responses. Fortunately, each of the speakers on this panel has some different tools to propose, I think, and for my part, I want to address the ways in which the coastal state can combat IUU fishing in the exclusive economic zone. In its 2015 advisory opinion on the request from the Sub-Regional Fisheries Commission, ITLOS stated that in light of the special rights and responsibilities given to the coastal state in the exclusive economic zone under the convention, the primary responsibility for taking the necessary measures to prevent, deter and eliminate IUU fishing rests with the coastal state. ITLOS also noted that although the convention approaches the issue of conservation and management of living resources from the perspective of obligations of the coastal state, these obligations entail corresponding rights. Unfortunately, the tribunal didn't elaborate on the relationship between these rights and obligations or how they correspond to one another. And in practice, the nature and extent of the rights that coastal states can employ to give effect to their obligations is not always that clear. Since the concept of IUU fishing didn't evolve until nearly 20 years after the adoption of UNCLOS, the rights and duties of the coastal state, elaborated in Part 5, don't contemplate the complex and constantly evolving types of activities that characterise IUU fishing, and nor are they addressed, obviously, in the 1993 Compliance Agreement or the 1995 Fish Stocks Agreement. The 2001 International Plan of Action to Prevent, Deter and Eliminate IUU Fishing, the IPOA-IUU, which was adopted actually 20 years ago just last month, envisages actions to prevent IUU fishing by flag states, by coastal states and by port states, and it sets out some measures that states should consider taking in these various capacities. But while the rights and responsibilities of port states and flag states with respect to IUU fishing have since been subject to further detailed elaboration in global instruments, and I'm referring to the 2009 Agreement on Port State Measures to Prevent, Deter and Eliminate IUU Fishing, and the 2014 Voluntary Guidelines for Flag State Performance, which have the same objective, there's been no further development or formal enunciation of the rights and responsibilities of coastal states with respect to IUU fishing. Now, this may simply be a recognition of the sovereign nature of the coastal state's rights over the living resources of the EEZ and the discretion that comes with that. But as we know, these rights are not unlimited. The legitimate exercise of the coastal state's sovereign rights requires consideration of the balance of interests inherent in the EEZ regime established in Part 5 of UNCLOS, in particular, the rights and duties of other states. However, in the absence of any specific measures in UNCLOS relating to the prevention of IUU fishing or the elaboration of such measures through other subsequent instruments, the balance that's reflected in the decisions of international courts and tribunals has not always involved interpreting the rights of coastal states in a way that enables them to fulfil this identified responsibility to prevent, deter and eliminate IUU fishing. In the course of my doctoral research, I sought to establish the contemporary nature and extent of coastal state jurisdiction over living resources in the EEZ by examining the practice of 135 coastal states. Drawing on that research, I want to highlight today three key areas in which I think coastal states can exercise their rights to regulate the activities of foreign fishing vessels in the EEZ in ways that will help them to fulfil this responsibility to prevent, deter and eliminate IUU fishing. The first is the regulation of not only fishing, but fishing-related vessels and activities in the EEZ. UNCLOS gives us very limited guidance on which vessels and which activities the coastal state may regulate in the EEZ. There's no indication as to whether the sovereign rights under Article 56 and the terms and conditions that may be imposed under Article 62.4 apply only to the activity of actually catching fish and the vessels involved in performing that activity, or whether they provide a basis for the regulation of a broader range of fishing-related activities and the range of fishing support vessels which enable those. The IPOA-IUU provides some clarification, suggesting that coastal states should ensure that at-sea transshipment and processing of fish in the EEZ is authorised by the coastal state or conducted under appropriate regulations. And the Port State Measures Agreement requires that port state measures be applied in relation to vessels involved in IUU fishing or fishing-related activities in support of such fishing, which are broadly defined to include any operation in support of or preparation for fishing. And of course, in the 2014 Virginia G case, ITLOS concluded that the coastal state's sovereign right to manage living resources includes the right to regulate the bunkering of foreign vessels engaged in fishing in the EEZ. My examination of coastal state laws and regulations has showed that in their contemporary practice, coastal states regulate a wide range of fishing and fishing-related activities in the EEZ, including all the ancillary operations that form part of modern industrial fishing. So processing, packaging and transshipping of fish, bunkering, also called refueling, and resupplying fishing vessels at sea, and assisting with the rotation of personnel and the conduct of repairs at sea. And this jurisdiction extends to the regulation of all the fishing and support vessels that are engaged in those fishing-related activities in the EEZ. So that includes foreign fishing vessels harvesting fish in the EEZ under licence, foreign fishing vessels engaged in fishing-related activities during transit through the EEZ, and the fishing support vessels, which are engaged in fishing-related activities in support of any fishing vessel, whether licensed or transiting in the EEZ. So how can coastal states use this regulatory authority, or perhaps jurisdictional opportunity, if you like, to prevent, deter and eliminate IUU fishing? The conduct of fishing-related activities at sea has significant potential, obviously, to facilitate IUU fishing and a number of associated crimes, because it enables vessels to avoid regulation. For example, by transshipping catch at sea, fishing vessels can obscure the real source of the catch and provide a legitimate pathway for its entry to port, while avoiding the scrutiny and enforcement associated with making physical port calls. These risks can be significantly reduced by the coastal state regulating or limiting the conduct of these fishing-related activities at sea. My examination of the practice shows that regulations that are adopted by coastal states in this context include obligations to provide prior notification of the conduct of fishing-related activities and reports upon their conclusion, requirements that authorisation be sought from the coastal state for the conduct of transshipment or bunkering at sea, requirements that bunkering or transshipment be conducted at specified locations or times, subject to supervision by authorised observers, and quite often involve the payment of fees. Some require they apply licensing requirements to fishing support vessels, and some coastal states prohibit at-sea transshipment. So by understanding the full extent of not only the activities, but the vessels to which such regulations can be applied, coastal states can maximise the application and effectiveness of their laws and reduce the number of vessels conducting fishing-related activities without regulation in their EEZs, and thus the likelihood of IUU fishing. The second area of opportunity I want to talk about is the grant of access to living resources in the EEZ. Article 62 of UNCLOS establishes a formula for coastal states to follow in regulating access to living resources in the EEZ. There's the obligation to establish whether there's a surplus, the criteria to be applied in allocating that surplus to foreign states, and terms and conditions that might be imposed on foreign vessels involved in extracting it. However, the text of Article 62 also provides almost unlimited discretion to the coastal state in how or whether this formula is actually applied, and contemporary practice shows that very few coastal states follow the framework that's established in the Convention. Instead, coastal states use this discretion to pursue a wide range of economic, social, security, and foreign policy objectives, and apply conditions that broaden the substantive, geographic, personal, and temporal application of their influence. So to me, this provides another significant opportunity to allocate access and impose terms and conditions in ways that can contribute to preventing, deterring, and eliminating IUU fishing. Most obviously, and as the IPOA-IUU suggests, in considering whether to grant access, the coastal state should consider the compliance history of the vessel and its owner, master and operator. However, given the complex way in which some ownership arrangements are structured and the ability for vessels to change names and flags, this approach has inherent limitations. So another option is to consider the flag state's record of compliance or enforcement cooperation. For example, in the United States, the criteria for apportionment of the surplus to foreign states includes whether and to what extent that state and its fishing fleet have cooperated with the United States in the enforcement of US fishing regulations. In addition to its historical record of compliance, coastal states might consider the likelihood of the flag state's prospective cooperation. For example, an access agreement might include a provision that establishes the responsibility of the flag state to ensure compliance by its vessels with both the access agreement and the fisheries legislation of the coastal state. Depending on the form of that agreement, this could potentially be enforced against the flag state through dispute settlement. The legislation of a number of coastal states requires the deposit of performance bonds prior to the commencement of fishing as surety for the vessel's compliance. Although I think there's a risk that this could simply just become the price of IUU fishing. Another approach is reflected in Timor-Leste's legislation, which provides that on the expiration of a fishing permit, Timor-Leste will issue an acquittance to the licence holder, indicating that there are no outstanding tariffs, fines or penalties resulting from the activities that were covered by the expired permit. While it's not a panacea for the difficulties involved in ascertaining the compliance history of foreign vessels, this sort of acquittal or certification could be useful to other coastal states considering the grant of a licence to that vessel, perhaps functioning as a positive indicator of compliance in contrast to the negative records such as IUU vessel lists, which are commonly used as the basis for assessing compliance history. The reach and effectiveness of these terms and conditions can be strengthened through cooperation between coastal states, particularly by using a regional register of foreign fishing vessels to collectively apply compliance conditions as part of the licensing process. For example, members of the Pacific Islands Foreign Fisheries Agency, we're fortunate to have the Director General speaking later on this panel. Those members have agreed not to license any foreign fishing vessel or fishing support vessel to operate in their EEZs unless that vessel is registered in what's known as good standing on the FFA vessel register. A vessel can be suspended from good standing if it contravenes the terms and conditions of access or the fisheries laws of any FFA member, or if it's listed on an IUU list. So this concept of good standing not only strengthens the effectiveness of FFA members' laws and regulations, but functions as a form of regional positive compliance list. The third area in which I think coastal states might consider regulation is the transit of unlicensed foreign fishing and support vessels through the EEZ. While all fishing activities conducted in the coastal state's EEZ without its permission or in contravention of its laws clearly fall within the broad category of legal fishing, the subset of unauthorised fishing activities that are conducted by unlicensed foreign vessels cloaked in the freedom of navigation pose particular challenges for coastal states. This situation involves a clash of interests between the flag state's right to ensure the free navigation of its vessels and the coastal state's need to ensure that this freedom isn't used to engage in illegal fishing. And this isn't addressed or resolved in UNCLOS or any of the subsequent instruments. While the literature has generally afforded coastal states quite narrow rights to regulate this situation, examination of contemporary law and practice provides a somewhat broader perspective. Since foreign fishing vessels only have the freedom to navigate and not the freedom to fish in the EEZ, any activities that might constitute fishing may not be conducted without the authorisation of the coastal state. As we've discussed, the coastal state's power to regulate fishing includes a full range of fishing-related activities that form part of modern industrial fishing, including processing, packaging, transshipping, bunkering, resupply and repair. So given the significant daily costs involved in operating a commercial fishing vessel, the only other activities in which a foreign fishing vessel is really likely to be legitimately engaged within the coastal state's EEZ are passage, so moving from one fishing ground or port to another, or extraordinary activities relating to force majeure or seeking or rendering assistance in situations of distress. So as such, I suggest that the freedom of navigation that may be exercised by a foreign fishing vessel in a coastal state's EEZ equates in practice to a right to undertake continuous and expeditious passage from one point beyond the EEZ to another point beyond the EEZ, except in circumstances involving force majeure or distress, or where the activities are undertaken with the authorization of the coastal state. So this understanding of the freedom of navigation for foreign fishing vessels transiting the EEZ provides a firmer basis to consider the ways in which a coastal state may assert jurisdiction over such vessels and the regulations that they might adopt to prevent, deter, and eliminate IUU fishing. The regulatory approaches currently applied and enforced by coastal states to vessels in transit include requirements relating to the stowage or carriage of fishing gear, measures relating to the route or mode of navigation, including the speed of transit, and prior notification to the coastal state of entry and exit, including information about the catch on board and intended route through the EEZ. Some coastal states provide that unlicensed foreign fishing vessels may only enter the EEZ for a purpose consistent with international law, which seems to equate to the narrowed freedom of navigation we've just discussed. And some require foreign fishing vessels to seek authorization prior to entering the EEZ, which will of course only be legitimate if it operates akin to a notification requirement, since consent to entry could not be legally refused. And in the legislation of many coastal states, these requirements are applied through the use of presumptions. So where does this examination of the practice leave us at the level of principle? Specifically, what does it mean for the way that we balance the rights and duties of coastal and other states in the EEZ under Part 5 of UNCLOS? Starting with a statement of ITLOS, in the SRFC advisory opinion, I suggest 3 simple propositions. If coastal states have the primary responsibility to prevent, deter, and eliminate IUU fishing in the EEZ, then the rights and duties of coastal states and other states must be interpreted in a way that allows coastal states to fulfill this responsibility. And in particular, the ceiling that is placed on the coastal state's rights must be interpreted in a way that keeps it above the floor of its responsibilities. Of course, this is a simplistic summary of a much more complicated equation, which involves balancing not only the rights and duties of the coastal state, but the rights and duties of other states, and in some cases, the interests of the international community as a whole, in order to preserve the compromise embedded in the sui generis regime for the EEZ. But if we are to effectively address the global problem of IUU fishing, it's an area where we need to get the balance right. So if you'd like more detail about this balance or about the practice on which this analysis is based, you can look out for my book on coastal state jurisdiction over living resources in the EEZ, which will be published by OUP toward the end of this year. And I look forward to your questions and discussion. Thank you.
Thank you very much for that, Camille. That was a really interesting discussion of what coastal states can do to regulate and manage illegal fishing in their exclusive economic zones. Our next speaker, Dr. Penelope Ridings, has an extremely long CV, so I'm going to stick to a couple of the highlights. She's currently a barrister and a legal advisor to the Western and Central Pacific Fisheries Commission. And very importantly, she is currently New Zealand's candidate for the International Law Commission. She has had many hats in her life, but I'll just mention that she is the former Chief Legal Advisor to New Zealand's Ministry of Foreign Affairs and Trade, and also a former ambassador. So, welcome, Penny.
Thank you very much, Joanna. I'm very pleased to attend this workshop. I want to first start by making a disclaimer that these views are my own views and they do not represent the views of the Western Central Pacific Fisheries Commission. The illegal, unreported and unregulated fishing, or IUU fishing, continues today despite decades of effort to curb the problem. And removing or disrupting the economic drivers which encourage IUU fishing will help to eradicate the global problem. And one of the ways that this is done is through sanctioning vessels involved in IUU fishing by denying them access to ports and thereby preventing their catch from entering the marketplace. And such action is premised on the identification of IUU fishing vessels. And this is done by regional fisheries management organisations, or RFMOs, which establish IUU vessel lists. And so this is the subject of my presentation. IUU vessel lists have become a major tool in the arsenal of measures to address IUU fishing. In this presentation, I examined first the reliance placed on RFMO IUU vessel lists. I briefly described the process for establishing those lists. I examined the action that is taken in response to IUU vessel listing by flag states, port states, and market states. I go on to describe some of the problems with IUU vessel lists, and then I turn to the future prospects of addressing some of these problems. So the role of IUU vessel lists is usually following a particular process which is similar in all RFMOs. So the first step is the submission of suitably documented evidence that a vessel is suspected of being engaged in IUU fishing and is therefore presumed to have undertaken IUU fishing. This is followed by the preparation by the RFMO Secretariat of a draft IUU vessel list and the circulation of the draft and evidence and the provision of an opportunity by the flag state to investigate and comment on the draft IUU vessel list. This is generally followed by an intermediate step, the creation of a provisional IUU vessel list, which includes the flag state response, and then the RFMO adopts the final IUU vessel list. The process usually provides for delisting the vessel or not putting the vessel on the list in specified circumstances, such as where effective action has been taken against the vessel, or there's been a change of ownership and the new owner has no involvement in IUU fishing. Once a vessel is engaged in IUU fishing and placed on an IUU vessel list, it's subject to severe consequences that flow from the fact of listing. These consequences arise either because of the requirements placed on members of the RFMO, or they're a result of the states being a party to the 2009 agreement on the port state measures to combat IUU fishing, or the port state measures agreement. In some cases, states also take unilateral action against vessels on IUU vessel lists. So the consequences of an IUU vessel being listed include that the flag state must withdraw the fishing authorization from the vessel. Members of the RFMO must ensure that its flag vessels do not engage in fishing activities with a vessel on an IUU vessel list, such as transshipment, bunkering, supply. Members are required not to permit the landing, transshipment, or provision of port services to vessels, and parties to the Port State Measures Agreement may either deny port access if it is sufficient proof of IUU fishing, and that includes inclusion on an RFMO IUU list, or it may allow entry in order to inspect the vessel. And if an IUU vessel enters port, the state must take action such as denial of landing, denial of landing catches, transshipment, and denial of access to port services. And a state may refuse to register a vessel that's on an IUU vessel list, and if it wants to be reflagged to that state. And if the WTO fisheries negotiations on subsidies come to fruition, it's expected that IUU listed vessels will not be permitted to receive fisheries subsidies. So addressing IUU fishing requires that each state or organisation involved plays a part in eliminating the practice. And this includes coastal states, as we've already heard from Dr. Goodman, flag states, port states, and market states. I should also mention that non-governmental organisations also play a role, and an increasingly important role. In particular, organisations such as Global Fishing Watch assist in bringing transparency to the activities of fishing vessels through tracking of automated identification system data. Ah, I see. I don't have. So there are a number of practical problems in addressing the use of IUU vessel lists. So first, there are a broad range of activities that fall within IUU fishing, and there's an inconsistent application between RFMOs. Under the International Plan of Action for IUU fishing, a range of different activities fall within what constitutes IUU fishing. These range from minor infractions of conservation measures, such as reporting violations, to serious violations, such as fishing without authorization. In practice, members of RFMOs tend to use IUU vessel lists to address two types of fishing activities. Fishing activities that contravene or undermine the effectiveness of RFMO measures on the high seas, or which involve fishing in the national jurisdiction of coastal states without or contrary to authorization. But there's often a lack of clarity over which vessels should be placed on IUU vessel lists. One difficulty is the lack of verifiable evidence of IUU fishing, and due process issues can also arise if listing processes are not applied in an equitable, transparent, and non-discriminatory way as envisaged by the IPOA IUU. Another problem is the potential for politicization of the IUU listing process through processes which enable a RFMO member to obstruct or prevent one of its vessels being placed on an IUU vessel list, even where there's clear evidence of IUU fishing. This is a problem as most RFMOs require such decisions to be taken by consensus. It is therefore very rare for a member of an RFMO to propose or agree to the listing of one of its vessels on the draft IUU vessel list. There's also the potential for illegal fishing in coastal state waters to be addressed through the placement of a vessel on a draft IUU vessel list in order to put pressure on the flag states to negotiate so that either action is taken in respect of the vessel, its master or operator, or there's satisfactory compensation paid to the coastal state for a violation of its laws. This is not problematic in itself, but it highlights the very different perspectives and approaches to IUU listing. It means that rarely are vessels that have violated coastal state laws placed on IUU vessel lists because some accommodation is often reached. Thirdly, the reliance on IUU vessel lists is only as good as the information on it. More often than not, there's insufficient detailed information included on the vessel list to enable a port state or flag state whose vessels are involved in transshipment to take action against such vessels. Identification details are often missing, such as IMO numbers or international radio call signs. This makes it very difficult to identify an IUU vessel that's changed its name or its flag, and the information contained on the IUU vessel list may be contradictory or out of date. And sometimes vessels are thought to have been scuttled or sunk, but they remain on the IUU vessel list. An FAO initiative to compile a global record of fishing vessels is intended to provide a tool to prevent, deter, and eliminate IUU fishing and related activities. This is a global database based on each vessel having a unique vessel identifier. The global record will make it more difficult and more expensive for vessels and companies acting illegally to avoid detection. 65 countries now have their vessels on the global record, so it's still a work in progress. Meantime, states must cooperate through networks such as the International Monitoring, Control and Surveillance Network to assist in identifying IUU vessels. But IUU vessel lists are concentrated on the vessels. The International Plan of Action on IUU fishing also emphasizes the need to exercise effective control over nationals, which covers not only flag vessels, but also persons involved in IUU fishing. But even though the IUU vessel lists can include information on the master, owner, or operator of a vessel, the consequences that flow from IUU vessel listing are on the vessel and not those engaged in operating the vessel. So my next point is that IUU vessel lists are designed to address vessel compliance. But there's increasingly a blurring of vessel-level compliance and flag state compliance. And this is despite the fact that they are addressed by different processes, vessel listing on the one hand and RFMO compliance mechanisms on the other. This most concretely comes to the fore when considering whether a vessel is to be placed on the final IUU vessel list. Most RFMOs provide for vessels not to be listed or to be removed from an IUU vessel list if the flag state has taken, quote, effective action against the vessel. This includes applying sanctions of adequate severity. The taking of effective action is a flag state responsibility. If the flag state has taken action, but if an RFMO member does not consider that this is of adequate severity, is this a flag state compliance issue or is this a vessel compliance issue? So some market states implicitly draw a distinction between flag state non-compliance and vessel non-compliance. For example, the European Union recognizes both IUU vessel lists established by RFMOs, and it also has a process in its IUU fishing regulation to identify countries which are not doing sufficient to address IUU fishing. The United States Seafood Import Monitoring Program, initiated in 2018, also has turned its attention to those countries whose nationals or vessels are involved in IUU fishing. So, the future prospects for addressing the problems which I've raised regarding IUU vessel lists. The issue of flag state compliance versus vessel compliance, which I have raised, this suggests my first suggestion. First, there needs to be a clearer identification of the purpose of IUU vessel lists. Are they for addressing rogue IUU vessels, or are they for addressing flag state compliance? Ensuring that the flag state exercises its responsibilities and ensuring that its vessels comply with conservation and management measures. So these are some basic questions of clarity that need to be understood and clarified. It makes a difference to how the IUU vessel lists are constructed and used. Without this clarity, the blurring of vessel compliance and flag state compliance, politicization of the RFMO decision-making process, and deficiencies in the IUU vessel lists will continue. But second, the IUU vessel lists identify a single vessel for listing. WCPFC and the Inter-American Tropical Tuna Commission provide the possibility for listing where an owner or of a vessel on an IUU fishing list has multiple vessels and enables the listing of those other vessels in its fleet. This is consistent with the idea that illegal fishing activities have an organized fleet-wide component to them. However, at least in WCPFC, the Western Central Pacific Fisheries Commission, this provision has not been used to date. Thirdly, there is no single global IUU vessel list, except for one constructed by an NGO which has no particular status. Although some RFMOs provide for cross-listing of the vessels of other RFMOs, this simply replicates the insufficient information that the RFMO has. A global IUU vessel list centralized at the FAO would be useful to enable port states to take appropriate action and to ensure that the information on the global list was robust, up-to-date, and as relevant as possible. But the purpose of IUU vessel lists is to shift the economic incentives so there's a disincentive on owners and operators to allow their vessels to continue IUU fishing. The IUU vessel lists do this through targeting the vessels, but there's a more effective way, namely the targeting of catches, so that there's actually a real constraint on illegal catches entering the market. Some market states, such as the European Union, already do this. Japan has recently passed legislation which will require imports to be accompanied by a certificate of legal catch. And work is underway by the Food and Agriculture Organization on seafood traceabilities, which may prove to reach dividends. So there was some real deficiencies in the operation of IUU vessel lists. They have not proved to be as effective as they were envisaged in the Port States Measures Agreement. But this suggests that more reliance needs to be placed on other tools, such as seafood traceability, in order to achieve the objective of eliminating IUU fishing. So it's clear that what is needed is a multi-pronged approach to dealing with IUU fishing, and this must include action to address catch traceability and action targeted not only at the vessels engaged in IUU fishing, but also the owners and the operators of those vessels. Thank you very much.
Right, our third speaker, I'm very pleased to introduce Dr. Manu Tupou-Roosen, who is the Director General of the Pacific Islands Forum Fisheries Agency. She has been working with the Foreign Fisheries Agency for many years and knows a lot about fisheries, and was formerly the legal counsel to the FFA. So please welcome Dr. Tupou-Roosen.
Thank you, Joanna, and warm Pacific greetings to all of you. It is a great honour for FFA to be part of this important seminar, and also to be with an incredible panel, and especially for myself following Dr. Ridings, who is an immense expert in this area. The topic that I'm looking at follows from what she's described in terms of the prospects and the challenges with IUU vessel lists. And what I'll focus on is exactly where she's left off, that it's a multi-pronged approach. It's not just looking at vessels compliance history, or as has been alluded to by Dr. Camille on flag state compliance history. It's looking specifically at the operators, the people that are involved and directly in control of IUU fishing. Can I just check that my screen is being shared? I'll double check with you, Joanna, first.
Sorry, it's not showing at the moment. If you share your screen, yes.
Okay, thank you.
And just start the slideshow. Yep, perfect.
Got it. Thank you. So in terms of an outline for this presentation, we're going to highlight just how important it is that we combat illegal fishing effectively by highlighting the importance of our tuna fisheries and the types of tools that we use in our monitoring, control, surveillance framework, a snapshot of that. And then we dive into this initiative from our FFA membership, looking at the collection of data, the categories of persons of interest that we're considering, and also this important topic of beneficial ownership and how exactly we identify these people. Dr. Penny's referred to the UVIs, and it's building on that concept in terms of what would be a unique person identifier, a UPI. I'm also going to time myself to make sure that I stay within your time frame, Joanna. There's just so much to say on the topic. So a snapshot as well about the geographical area that we're looking at, and it's over 20% of the world's EEZs. And in 2019, which is our latest data on tuna catch, the highest record was in 2019 in the Western Central Pacific Ocean. It was nearly 3 million metric tons, and that's over 50% of the global tuna catch, so quite significant. And if we carve out just from that what came from our FFA members' waters in the WCPO, it's about a third of the global tuna catch and valued around $3 billion US. Looking at government revenue, and this continues to trek upwards, it's over $500 million US to our island economies. In terms of employment, it's nearly 25,000 jobs. And importantly for food security, the increasing role of tuna to supplement local food security needs. And that's at the heart of all this, is our people, and ensuring that they can enjoy the greatest benefits from the sustainable use of our tuna fisheries resources. And central to all of this work is cooperation, and that's been the cornerstone of success for our membership over the last 40 plus years. We're proud to say that it's the best managed and largest tuna fishery in the world, and that's not to say we're complacent. We must continue to work hard to put in place robust management measures to maintain this status. Looking at the IUU challenge faced specifically in the Pacific, we did a quantification study a few years ago, which is updated this year. And what it told us is that in terms of fish that are caught illegally or transshipped illegally, it is estimated to cost over $600 million US. In terms of the direct economic impact, the type of income that we would get through access agreements that is valued at over 150 million US dollars. The other important finding from this study is that we're not looking at the pure illegal unauthorized fishing vessels anymore. It is the licensed vessels, those that we authorize to fish within our waters, and the challenge is either misreporting or underreporting or not reporting. So looking at the tools that our membership have put in place to combat illegal fishing, and especially this heightened challenge of underreporting of catch. Our members have put in place a suite of tools over so many years. And for example, if I point to the regional surveillance picture, which is just at the top of the screen, this is basically a picture of all the vessels that are licensed to fish in our waters and are tracked by satellite, and it's color-coded according to the vessel compliance history. And so that leads us nicely to why we must also look at those who control those vessels. And when we look across the suite of the MCS framework, it's very heavily focused on vessels, as has been underlined by Dr. Penny in highlighting the tools for RFMOs. So focusing on persons of interest, we're looking specifically, as mentioned, at those people who are controlling the vessel. This could include the owner, the charterer, the master, the fishing master. We're looking at both natural persons and legal persons, and hence this Persons of Interest project and initiative by our membership. And really at the heart of this as well is going behind the corporate veil and uncovering the beneficial owners, those that ultimately control and ultimately benefit, including from illegal activity. What I've provided here is just a snapshot of the work of the members for quite some time in terms of this Persons of Interest project. The newer treaty subsidiary agreement for surveillance and enforcement, it's an agreement where our members determine that there's specific data that must be collected, one of which is persons of interest. So really looking at the work on operators of vessels. Our members also endorsed a draft persons of interest strategy, which looks at certain outcomes. Foremost in these, the legal basis to undertake this work, especially considering any privacy concerns. So throughout the years, I've mapped out here the types of tasks that have been undertaken, but most recently, the one I'll point you to is guidelines and procedures that our members are yet to consider, which will set out the types of ways that we could address this initiative. Some of which I'll go to now. The first one I'll highlight here is in terms of the collection of persons of interest data, and really underlining up front the purpose and why we do this. And it's to ensure that we can better target our limited monitoring, control, surveillance effort. And also, I highlighted up front, the map really shows the sheer challenge of the area that we're dealing with. So targeting those limited resources, also providing better information for our decision makers. And it is a means to verify information from RFMOs. So ensuring that we have at the fingertips of our decision makers, not just the vessel compliance history or any other type of history related to the vessel or the flag state, but importantly, the applicant, and behind the applicant, the company and all the people that are involved with the vessel, and having that information ready, especially in terms of the compliance history of those persons. This will require collection of the information from our membership, and it's intended that this be housed into a database held at the FFA Secretariat to assist in the decision-making undertaken at national level. This information will obviously be extensive. We're looking, as I said, not just at natural, but also legal persons that are associated with the vessels, which the member is going to authorize to fish, and they'll be housed with the vessel registration information. Also looking at the information regarding the activity of the vessel, and I'll step into that next because that's relevant for the categories of persons of interest that we're looking to put in place. So we've got 3 categories for what we're looking for with persons of interest. Category A consists of those that are associated with a vessel, which is liable to be refused good standing. So either they've been convicted of a serious offense and they haven't complied with a judgment in connection with that offense, or there's evidence that the operator has committed such offense but hasn't been possible to bring that person to trial. For example, they've fled the jurisdiction of our coastal state. And also if they've used fishing methods or gear that are banned or considered harmful by our Forum Fisheries Committee, by our governing council body, such as drift net fishing. An obvious one that links also to Dr. Penny's presentation is if the vessel has been listed on an IUU vessel list. And Dr. Camille highlighted that one of the tools or measures that we use is that if an applicant for a vessel that's on an IUU vessel list is, if there's an application to our vessel register, that this would be rejected. Looking at category B, persons of interest, these are people that are associated with vessels involved in offences, including serious offences that we have just listed under category A, but no longer warrant category A listing. For example, the case has been fully adjudicated before national courts and all penalties paid, settlements of serious violations where the vessel information has been publicly listed, recidivist offenders, multiple violations which together constitute a serious disregard of measures, or category B could also be where a person has been found guilty of a transnational crime, or where a crew member has been involved in an assault or there's been interference with the work of the authorized observer. Category B information may be taken into account by national decision makers before they issue a license. So as highlighted earlier, having that information at our decision makers' fingertips to take the ultimate decision of whether this is a person that they trust to operate in their waters. The final category of those that are persons to watch. And so it's a working arrangement. There's a possibility that they've been fishing in a closed area, for example, but it's yet to be determined with the relevant coastal state on the conditions of their license, or it might be reflected as an unlicensed vessel in our database at FFA, but we need to cross-check that with countries because sometimes there's a lag between licensing information that we receive. So those are persons to watch. The types of individuals that we'd be looking at for this listing are owners, directors, de facto directors, shadow directors, charterers, operators, masters, fishing masters, and navigators. In terms of beneficial ownership, we recognize just how important it is to go behind that corporate veil. And so sometimes it could be obvious, the legal owner is the beneficial owner, but most times it is hidden. And so there's important work there to be done to uncover this. This is a definition that we found in Nauru's legislation, which we found quite useful. A beneficial owner is a natural person with ultimate control, directly or indirectly, over the legal entity, who ultimately owns the legal entity or on whose behalf the legal entity is created. We're looking at a practical approach in line with international approaches, would be for each member to require the details of the ultimate beneficial owner of the vessel, where it could amount to 25% or more, or where the person has effective control of the vessel. And it could also be a cumulative amount that amounts to 25% ownership. The EU has suggested another approach to just list the 5 largest beneficial owners behind a vessel, but is not one that the FFA is keen to follow. Now, with the unique person identifier, this is a problem, especially where the characters are used in non-Latin alphabets. And so first point of reference for us would be the passport number, but we know that there's challenges with that as well, with the use of false passport. Also, a lot of crew don't have passports and looking, for example, at something like a seafarer's certificate instead. A more complex approach would be to set up an actual UPI register, and similar to the International Maritime Organization scheme. And a possible option for future might be a biometric identification system. So this is all still being considered. Where the original passport is not available for inspection by the member, a certified copy of the biodata page. If the passport's not in English, a certified English language translation. So the type of information to be obtained is the name, address, date of birth, and passport number of master, fishing master, navigator, and charterer. In addition, of course, the name of the vessel, IMO number, which doesn't change, and this is to be sent to the FFA Secretariat. Given that we're the first point of reference before any authorizations are given at national level, a vessel cannot be licensed to fish by any of our members unless they are first registered at the FFA Secretariat. Just underlining here just how crucial it would be to get the information at the application stage, including beneficial ownership. Otherwise, the incentive's not there afterwards, and we would need a regulation power for information to be obtained later if the original information is found to be incomplete, and that this be accompanied by a power that we could cancel any authorization that had been given. We're ending with this slide to just remember why we do what we do and why we must give it our best. Our people, our fisheries, our future. Thank you.
Thank you so much, Dr. Tupou-Roosen. That was fascinating to see an insider's perspective on the challenges for regulating IUU fishing. Our final speaker and our first joining us from Japan today is Dr. Makoto Seta, who is an associate professor at Yokohama City University in Japan. We were actually fortunate to welcome him last year in Wellington just before travel was suspended due to COVID. So I'm very glad to see you again, but in line this time.
Yep. Thank you, Joanna. And can you see my slides?
Yes, we can.
Okay, thank you. So, kia ora, good afternoon. My name is Makoto Seta, Associate Professor of International Law at Yokohama City University, Japan. I would like to extend my sincere gratitude to the organizer of this workshop, so Joanna, and the Embassy of Japan in New Zealand, and all the participants. So just before the COVID-19 pandemic became serious, so as Joanna explained, so I went to Wellington and enjoyed myself very much. So it's a pity that I can't visit this time. But when I visited last time, so I bought Maori greenstone for my wife, and she really likes it. So considering this fact, not visiting Wellington saves my money probably. So anyway, I'm looking forward to visiting again and having a face-to-face meeting with you after the pandemic is over. The title of my presentation is Criminalization of IUU Fishing from the Perspective of Principles of State Jurisdiction. On criminalization of IUU fishing, I have studied for several years, and I made a presentation on this topic in the ILA biannual conference in Sydney in 2018. So, but because of my lazy character, I haven't written an article on this topic. And since then, I have improved my idea. And today I will talk about it from a different perspective. So perspectives of the principles of state jurisdiction. This is the contents of my presentation. So thanks to my colleagues, I'm sure that I don't need to provide basic information on IUU fishing. So after introducing the topic, so I will explain the criminalization of IUU fishing, then examining criminalization from the perspective of principles of state jurisdiction, and I will make a conclusion. I'm sure that most of you are familiar with this picture. So that shows Indonesia exploded vessels engaging in IUU fishing. So it is a measure taken in accordance with Indonesian law. Indonesian government took such measures because it is really suffering from IUU fishing. And as this example shows, now many states as well as non-state actors take several multiple measures against IUU fishing. This chart is a kind of list of measures to tackle IUU fishing. As Dr. Reddings explained, the listing of vessel is expected to be one of the effective methods. Also, recently, this CDS catch documentation schemes is strengthened in both EU and United States, and also looks to work. And I believe that criminalization can be one of the methods to work. And the Indonesian government strongly supports this idea, but this arrow might be a little bit misleading, because I think criminalization can be connected to or assist other methods. So now CDS is applied in EU and the United States market, and the violation of CDS regulation can be criminalized. So in this way, so criminalization can support the other methods to fight against the IUU fishing. So this diagram demonstrates the links between IUU fishing and other crimes, i.e. fisheries-related crimes, and crimes associated with the fisheries sectors. Fisheries-related crimes are closely linked with the fishing operation, even if not considered IUU fishing itself. Examples of fisheries-related crimes are forged fishing license or forced labor. Crimes associated with the fisheries sectors are crimes that have no direct connection with fishing operations, but take place on fishing vessels or during a fishing operation and using the fishing operation as a cover, opportunity, or means to commit such crimes. So examples of these include drug trafficking and piracy. So this is why Indonesian government said fishing crime should be categorized as transnational organized crime. And actually, the close relationship between illegal fishing is supported not only by Indonesia and FAO, but also Interpol and UNODC. So they published several documents to demonstrate the link between IUU fishing and the so-called UNTOC crimes. But in this presentation, I will focus on the criminalization of IUU fishing itself at first, and fisheries-related crimes to the extent it is relevant. So these two circles. So I'd like to clarify what criminalization means at the beginning. So in this presentation, it means the process by which behaviors are transformed into crime. Currently, in most states, IUU fishing or some illegal fishings are administrative offenses and not criminal ones. So criminalization turns such administrative offenses into criminal ones. As a result, public perception of such offenses is expected to be changed. With regard to the process of criminalization, there are two ways. So one is criminalization by international law, and the other one is criminalization by municipal law. A typical example of the first one is the Genocide Convention. After its adoption, many states established domestic legislation to criminalize genocide. The other way around, so sometimes crimes under domestic law become international crimes. Traditional piracies were punished without the definition of international treaties, and such practices led to the adoption of international definition of piracy in the High Seas Convention. So what I want to highlight here is the fact that the contemporary international system, without criminalization of municipal law, it is difficult to enforce criminal norm. So this back and forth between international and municipal law seems important to criminalize some acts globally. I personally consider that criminalization conceptualized in this way can be an excellent tool to fight against IUU fishing because of the following three reasons. First, as I said, criminalization can change public perception. If we successfully label IUU fishing as a crime, it would deter IUU fishing. Also, this change of public perception would enable states to engage in international cooperation more easily. Second, we can utilize the existing criminal system. Primarily, we can rely on the procedure of international cooperation in criminal matters. For example, now most states conclude the bilateral treaties on extradition or mutual cooperation on criminal matters. In criminal proceedings, those treaty frameworks of international cooperation can be utilized. Also, international organizations such as Interpol would be able to play a more important role in the investigation. Since each state has its own criminal system, technically it would be easier for states to introduce IUU fishing into such a system. But on this point, I have to note the fact that the criminal system has its own culture, and therefore sometimes it's quite difficult for some states to incorporate new factors, new elements. And third, so this is a reason from a little bit different perspective, but criminal jurisdiction is a typical example of principles of state jurisdiction under international law. So we can easily refer to these principles. This is a chart of relevant states to IUU fishing: coastal states, market states, port states, flag states, and the states of nationality. So it's a little bit, I think, misspelling, so many misspellings, so sorry. So it's a states of nationality. That is a state of which a person is a national. So those states may have jurisdiction against IUU fishing on different bases of jurisdiction. So coastal states and market states may exercise their jurisdiction based on the territorial principle. Port states may be based on both territorial and universal principle. Flag states and states of nationality are based on nationality principle. So, I will elaborate one by one. So first, coastal states. Since states have their sovereignty up to their territorial waters, they can apply their criminal law to that area. Over EEZ, so which Camille examined, so what states have is sovereign right and not sovereignty itself. So its scope is limited and some conditions are stipulated. So Article 73 of the UNCLOS, paragraph 3 provides coastal state penalties for violation of fishery laws and regulations in the exclusive economic zone may not include imprisonment in the absence of agreement to the contrary by states concerned. So basically, coastal states cannot impose imprisonment. But if states concerned, so which are said to be flag states and states of nationality, say it is okay, coastal states may impose such strict criminal penalty. Second, market states. So since market states are not directly involved with fishing, what they are expected to criminalize is not fishing itself, rather market-related crimes such as illegal trafficking and documentary forgery for the CDS. So their exercise of jurisdiction can be justified on the basis of territorial principle. Third, port states. If a fisherman of the fishing vessel tried to show the falsified document, the port state could exercise jurisdiction based on the territorial principle, because a crime, so demonstration of the falsified document, is conducted within the territory of the port state. However, against the IUU fishing itself, if such crimes committed on the area beyond the waters of port states by foreign vessels and people, port states do not have any nexus against such IUU fishing. Therefore, if a port state tries to exercise its criminal jurisdiction over such crimes, they must be based on the universality principle. Although such exercise of jurisdiction is not allowed under the existing treaties framework, from theoretical perspective, IUU fishing can be subjected to universal jurisdiction, given the similarity to the vessel source pollution on the high seas, which is subject to universal jurisdiction under Article 218 of the UNCLOS. Because IUU fishing can be regarded as violating the common interest of the international community as a whole. I think this understanding is supported by the Madrid-Buenos Aires principles of universal jurisdiction. Fourth, flag states. If flag states properly criminalize IUU fishing and enforce it, so I think most problems of the IUU fishing could be solved. So on this point, so many provisions of UNCLOS and customary law, as well as RFMO rules, request the flag states to take some measures, but they look not to oblige criminalization to the flag states. And lastly, states of nationality, I think which gets attention recently. A state has jurisdiction over its nationals based on the active personality principle under customary international law. And based on this fact, Article 62.4 and 117 of the UNCLOS look to request states of nationality to regulate their own nationals. However, they also do not request criminalization. In the case of RFMO, for example, Article 5 of the NPAFC Convention provides each party shall take all necessary measures to ensure that its nationals comply with the provision of this convention. So it might be possible to say that all necessary measures should be interpreted to include criminalization, but I'm sure that this interpretation is not widely supported. The most strict regulation against IUU fishing can be found in the EU measures. EU takes a severe position against IUU fishing, and some of its member states actually criminalize IUU fishing within its municipal law. However, other member states appear to struggle with criminalization. So Spanish authority tried to prosecute IUU fishing conducted by its nationals, but it failed because IUU fishing is administrative offenses and not criminal ones, and therefore active nationality principle cannot be extended. Also, the problem of dual criminality was raised in the Spanish case. On the other hand, some Asian states successfully criminalized IUU fishing after they were required by the EU to regulate IUU fishing. And actually, Thai government successfully imposed criminal penalties on its nationals who committed IUU fishing on the stateless vessels engaging in illegal fishing on the high seas. Conclusion. So to enforce fishing regulations, the global criminalization is one of the methods to be adopted. As I explained, some states, such as coastal states and flag states, so it's clear that they have criminal jurisdiction over IUU fishing. On the other hand, port states or states of nationality need to clarify their rights and conditions for exercising at the first set out. In addition, in order to expect states to exercise such jurisdiction, we need to establish an obligation to criminalize IUU fishing, though it seems very difficult. Also, to enhance the contribution of market states, it might be better for us to consider the responsibility of legal entities. However, as Article 5 bis of the SWA protocol also admits, the non-criminal liability, different types of liability from criminal responsibility might be better. So this is the end of this presentation. So this is the end of my presentation. So Kapai, thank you very much. And so this is the list of main references. So thank you.
So thank you very much, Makoto-san. That was really interesting.